Thursday, May 23rd, 2019, regular meeting of the Brisbane Planning Commission will now come to order. May I have roll call, please?
Commissioner Gooding?
Here.
Commissioner Mackin?
Here.
Commissioner Patel?
Here.
Commissioner Sison?
Here.
The record show Commissioner Gomez is absent.
Adoption of the agenda. May I have a motion to adopt the agenda, please?
So moved.
Second.
All in favor?
Aye.
Aye. Consent calendar. We have two items. One is the approval of the draft action minutes for our regular meeting of April 25, 2019. The other is General Plan Conformity GPC-1-19, General Plan Sierra Point SPC/R/O sub area. Is there anyone who would like to remove an item from the consent calendar for discussion? I see no one. May I have a motion?
I have a question.
Okay.
I have some questions as it relates to the general plan conformity. So how do I go about doing that?
I would just go ahead and pull it off the consent calendar and move it to the end of after old business.
Okay.
I would ask to do that.
May I have a motion?
I move to move the general plan conformity GPC-1-19 off of the consent calendar.
And a second?
I'll second.
Before we vote,
Can you also,
excuse me, can we put that, you want to put that after item number 1 on old business?
Right. We'll do
Yes.
that at the end. Yes.
Yeah.
and could you also adopt the consent calendar with that amendment?
Yes. So we have a motion to remove general plan conformity GPC-1-19 for further discussion later towards the end of the meeting, and to adopt the draft action minutes of April 25, 2019.
So moved.
All in favor?
Aye.
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 Next is oral communications. Is there anyone who would like to address the commission about an item that's not on tonight's agenda? I see no one. We'll move on to written communications. I have 5 letters here concerning the subject of our public hearing tonight, and these 5 letters are all in support of the commission granting the variance, and the letters are from residents Dan Carter, Tony Press, Diane Van Stralen, Luke Bouchard, and Kathy Wall. So now we will address the continuation of the public hearing regarding 296 San Benito Road, R-1 Residential District, variance V-1-19, and grading review EX-1-19. This was a variance and grading review to allow demolition of an existing single-family home and construction of a new 1,794.5 square foot single-family home on a 2,300 square foot lot, exceeding the maximum permitted floor area ratio by approximately 138.5 square feet, and requiring export of 95 cubic yards of soil from the site. Jerry Cool is the applicant, and Paul and Glenda Jimenez are the owners. Staff, may we have an updated report?
Yes, good evening, Chair and Commission. So this item was continued from the April 25th meeting, and we prepared a supplemental report to address some of the items that were brought up at that hearing, both by the Commission, the applicant, and the public. So I'll kind of briefly go over them here. And then also, before we really dig in, I wanted to kind of reiterate how we measure floor area, what is floor area, and what is the floor area ratio, especially as it pertains to this particular project. So this is an excerpt from the applicant's plans that's in the plan set, and we discussed it last time, but I'll kind of go over it again. So what this floor plan diagram shows is what is actually counted as floor area for the purposes of what the FAR is for this project. So you'll see on the far right, the first floor plan has several areas I've circled, or not circled, but put squares on top of the areas that are not counted towards the floor area because they don't meet the definition. So that would either be they're less than 6 feet in height, or like for crawl space, there is no finished floor, or for the portion of the garage that's excluded, it's that 200 square foot exemption. So just to kind of reiterate, that's what floor area is, that's what we're measuring in this case, and how we arrived at the floor area for the project before you. So at the April 25th hearing, it was brought up that there was another home on the block at 276 San Benito Road that had about a .93 FAR that was constructed in the recent past that had a two-car garage and, was over the .72 FAR. So we researched the circumstances of that, and having only worked here for 4.5 years, I wasn't here in 2002 when Ordinance 463 was adopted. That actually was the first time the city adopted FAR standards for this district. It was previously referred to as a different kind of district, but the R1 district, those regulations were adopted in 2002. So that's why the home at 276 San Benito Road is constructed the way it was. It complied with lot coverage, setbacks, height. We didn't have FAR limits on it. So that was through Ordinance 463 in 2002. Also included in Ordinance 463, just kind of as an interesting matter related to that square footage exemption for garages. In that ordinance in 2002, the exemption was up to 400 square feet for covered parking on a lot less than 3,700 square feet. That was reduced to 200 square feet in 2004 through Ordinance 485. So that's just kind of a history of how the current regulations came to be and how they relate to development that you might see on that block that is currently non-conforming. So hand in hand with that, since there were no FAR regulations until 2002, logically there were no FAR variance requests until after that date. So since that time, the Commission has heard 3 requests for FAR variances from 2003 to 2008. 2 of those requests were denied for, both of those were associated with new developments. There was a request in 2007 for an FAR variance to allow additions to an existing home that had an existing non-conforming FAR. That was approved. Obviously, each case being different, the circumstances being different, we summarized the findings in the staff report, so I won't repeat them here, but that's the history of FAR variances thus far. Okay, and then moving on, there was also some discussion that there are other homes on in the vicinity that enjoy 2-car garages that are also substandard in size. So again, we didn't do an exhaustive survey of the entire neighborhood, but we did look at the 200 block of San Benito Road, both odd and even sides, to see what kind of garage development there was. So of the 11 substandard lots with garages on the 200 block of San Benito Road, 4 have 2-car garages. 3 of those 4 comply with the FAR max. 1 exceeds the FAR max, and that's 276 San Benito Road, which again was constructed prior to the adoption of the FAR max. So we also attached to your staff report a handout from the Governor's Office of Planning and Research that addresses some of the questions brought up by the Commission about when we're thinking about special circumstances, what really does that mean? What are privileges? So hopefully that was a helpful resource to the Commission. And lastly, there, as noted by the chair, were several written correspondence submitted to you on the dais. We also had one letter that was submitted in time to be attached to the staff report, so that was attached to your report. So I'll kind of conclude my report here. We're continuing to recommend denial of the variance and then recommend approval of the grading permit application with the condition the house be redesigned to comply. Depending on where the discussion goes tonight, should the Commission wish to approve the requested variance, you will have to make those affirmative findings that are outlined in the staff report, and likely would be looking at a continuance again. But we'll open it up to questions in the public hearing before seeing where that goes. So I'm happy to answer any questions.
Thank you. Any questions for staff?
No.
Nope. Okay, then we will open the public hearing. I have a note here that Dan Carter would like to address the Commission.
Oh, the applicant also is.
Oh, the applicant is here.
The applicant's representative.
Yes, it got weird.
Oh, okay, Mr. Burchard.
Madam Chairperson, my apologies for my surprise here. Apparently, I've been deputized by Mr. Jerry Cool, who was or is the designer for the applicants. He suffered or he underwent a major surgery recently, and I just learned a few moments ago that I'd been deputized to represent the application. So here I am, your humble servant. If you have any questions, I don't know. I've never represented somebody pinch-headed like that. So. Yes, I missed that email myself. I was at baseball practice in the last 2 hours, so. Well, I'll say a couple things that I took notes on. Would it be acceptable for me to ask a question of staff, actually?
Sure.
Is that acceptable?
Sure.
Yes. So on page G12 of the staff report, in the paragraph just below the table that's included there, I'll read the quote here. Staff does not believe that historic development that was constructed in compliance in the zoning regulations in effect at the time of construction is enjoying a privilege that is being denied the current applicant, and therefore this finding is not met on the basis of this comparison. If I understand that statement correctly, I believe it means that staff is expressing an opinion that if there are other homes in the vicinity in the same current identical zoning district, that they are not to be considered as enjoying a privilege because at the time that the development was made, they were compliant to all regulations. Do I have that correctly? Okay. May I ask where in the Brisbane Municipal Code that exclusion of prior compliance is included?
That's a staff finding, it's a recommendation, it's staff's opinion, it's not written in the code.
Okay. So continuing with that, the privilege that is expressed by staff opinion.
Sorry, I have a question.
Oh.
Can I ask a question?
Sure, go ahead.
Okay.
Commissioner.
I have a question.
Yes, sir.
So, is it your position that if the city council changes the code after a certain date, that if there was ever a time when there were certain things that were allowed, that the code doesn't have to be followed after the city council has adopted it?
Not at all. I was curious.
Oh, okay.
One could infer that from the question. That's not where I was going.
Okay.
Where I was going is that staff expresses here a belief that there's no privilege enjoyed if the privilege was developed, my words, not staff's words, at a time where regulations allowed for that thing. In this case, an FAR going above a certain limit that was instituted after the construction was done. And this is specifically, I believe, referring to, I believe it was 276 San Benito. What surprises me about that is in one paragraph, staff expresses both a belief and a qualification of privilege, and later in the same page under variance findings, quote, as staff previously indicated, there are no definitions in the zoning ordinance for the terms privilege and special circumstances relative to variance findings. These terms have been interpreted by the commission on a case-by-case basis as appropriate to the project in site in question and nature of the variance request. So in my view, I'm a bit confused. Either it is up to commission to introduce or to, not introduce, but to do the interpretation of what constitutes a privilege based on Brisbane Municipal Code and your respective opinions, because in Brisbane Municipal Code there is not a definition of privilege or special circumstances. That's bucket number one. And if we follow that, I found no place in the Brisbane Municipal Code, and that's why I was asking staff, where it said that if what could be construed as a privilege today, if when it was acquired by a property, it was legal and it was not a derogation from any regulation, it is to be ignored. Right? I'm confused by that. Either you believe that it's up to the commission to find a privilege by your own judgment, or it's not.
I have another question.
Yes, sir.
Do you think that the commission has to follow the law that the city council has passed?
Absolutely.
So if the city council has passed a ordinance that not only stipulates what percentage of a lot can be covered, what the setbacks are, what the height requirements are, but also includes after 2002 or 2003 something that says that the volume must also be less than 72%. Do you think that it's our job to follow that, even if we potentially disagree with it, even if a project is in place that seems in all ways reasonable, but this is a law that's been passed by the city council? Do we just ignore it?
Absolutely not. I certainly, and I don't believe that Jerry Cool would, or the applicants would suggest that any law be ignored. The total body of the law that governs Brisbane Municipal Code says, here are the rules, and the rules are always a starting point. Why is 2,500 square foot a standard lot? Why not 2,498 or 2,502? I'm using that rhetorically here, right? There's a starting point. Same thing with 5,000 square foot where you're entitled to an in-law unit and so on and so on.
So would you, sorry.
One last point.
Yeah, sorry,
Apologies,
I
Commissioner.
apologize for interrupting.
So if you use that as the starting point, and you say the law is the law, and you stop there, there's no need for a variance process. There's no need for a planning commission for that particular, role that you guys play. There is such a thing as a variance process. Title 17, in fact, 1746.010 and 1746.020 spell out the conditions. So in the code, we find what governs the exceptions to the code. And I don't find that a paradox at all. I find that to be wisdom. It's wisdom that those who enact rules say, here's the rules as we believe them to be fair and just for everybody. There are times, unforeseen conditions perhaps, or special circumstances where those rules, well, maybe they don't apply. It would not be fair to apply them as is, right? So I believe in broad strokes, that's the merit of the Brisbane Municipal Code, having a variance process. Now, as we enter a variance process, it goes through an applicant asking for variance. We have that. And they have to show, they have to pay a fee. They have to explain why they're asking for variance. And all that's been done by applicant. And certainly we have all the documentation here. And here we are where it's not an exception to the Brisbane Municipal Code that's happening. You're operating well within the Brisbane Municipal Code to evaluate a variance request. So nobody's ignoring or throwing away any paragraph of the code. You are being asked to look at a variance request. And there's guidelines there. You must do a finding of fact that indeed the strict application of the rules would deny the applicant a privilege enjoyed by others in the same vicinity, in the same district or zoning district. So if you cannot find that, then you're free to vote your conscience, so to speak, and say, no, I don't find that, I don't want it. If you do find that there are special circumstances that apply to this particular property, and that you can do a finding of fact, basically write down why you find that in this case it's okay, then you can vote that too, right? And all that is legal and within the municipal code. Now, I'm no attorney, but that's my understanding of it.
I have another question.
Go ahead.
So, when the city council adopted this resolution that limited volume of houses, and in addition to these other setback rules, percentage of lot coverage rules, and height rules, they actually also included a little piece that said that if there is a smaller lot, you get to subtract 280 square feet or something like
200.
that. 200 square feet. I'm
It
sorry.
started at
What is it?
400 and then was reduced to,
Technically, it started at 400 and then subsequently was reduced to 200.
Okay, so they've taken into consideration special requirements that are associated with smaller lots. So how is that not already been considered when they sort of passed this law?
you're quite right that for lots smaller than 3,700 square feet, there is a statutory exemption, or deduction, I should say, of 200 square feet of FAR granted to those lots. Now, a lot of 0 square feet up to 3,700 square feet, they all get the same 200 square foot exemption. That is a one-size-fits-all exemption for all sizes of lots.
Right.
As you well know, the the special circumstances explicitly lists a few, and my apologies. noted somewhere. I won't try to quote it, I can't find it at the moment, but the Brisbane Municipal Code 1746-010 subsection B, I believe it's subsection B, it could be subsection A, where it defines what special circumstances might be. It does list, oh, there you go, this evaluation, so special circumstances applicable to the subject property including size, shape, topography, location, or surroundings. So in the very paragraph that says what should the planning commissioners look for to qualify a property as having special circumstances, the item of size is included, right? So that tells me that in its wisdom, the Brisbane Municipal Code says, all right, there's a statutory deduction of 200 square feet of FAR for anything south of 3,700 square feet. And that's given to everybody no matter the size. Should there be special considerations in certain cases if the lot is much smaller? It's not spelled out, but it is more than hinted at in the very paragraph that brings us here tonight, which defines special circumstances that could be looked at by commissioners to see if there is, reason to do a finding of fact that this variance can go ahead.
Sorry. But when the Brisbane City Council made this law in 2003, which I don't know why they did, seems like there were already enough restrictions on building. But when they did, wouldn't they have also considered, they considered giving a certain amount of square footage to these lots that are different sizes. Wouldn't they have considered, the difference between a 35,000 square foot lot and a 10,000 square foot lot and a 0 square foot lot? And isn't that the appropriate time to maybe address those issues as to, well, what's going to happen to these different size lots when you're passing this law versus us now second guessing what they already passed?
Yeah, I cannot speak on behalf of those who were members of the city council at the time, nor those who are members of the city council today. I can give you an opinion as to how laws work. Laws try to be as precise as is required while remaining practical. So there are a number of boundaries of lot sizes that are included in the code for various uses. For instance, in some zoning in Brisbane, you cannot legally create a sub-conforming lot. And I hope I use the terms correctly, but if, for instance, tomorrow morning I were to buy a 7,000 square foot parcel of land, I could not, and that's conforming, that's more than 5,000 square feet. I could not subdivide it into two lots because, invariably I would be creating at least one, perhaps two non-conforming lots, right? So I'm just using that as an example of there are various boundaries of sizes of lots that are used for different uses in the law. Now, coming back to the FAR, to my knowledge, which is limited and focused on this particular application, there is one statutory size that applies to a deduction in FAR, which is 3,700 square feet. And the applicants get the benefit of that deduction in the calculation of how many square feet count towards the FAR, as staff has explained. There's another boundary that applies to the applicant's situation, is that as the city of was it the city of Visitation before it became Brisbane?
The subdivision map was City of Visitation, but it was never a City of Visitation.
Thank you. So in the subdivision map, my understanding is that the original landowners that subdivided them and were selling the lots, they were trying to get the lots to be roughly 2,500 square feet. And because of topography and various other situations, some of the lots ended up being much smaller, right? In this case, the applicants, not only do they not have a conforming lot, because it's less than 5,000 square feet, they're less than 2,500 square feet, which makes it a substandard lot. Now, I'd like to note that the design as it exists today, were the lot 2,500 square feet, which it's not, but were it 2,500 square feet, the FAR that is being requested would be compliant. It would be an administrative process, not in need of a variance, right? So in this case, what essentially the applicants are asking for, one angle to look at it from, is that they have a smaller lot. Nobody denies that. That's a fact, that's not an opinion. The fact that they have a smaller lot limits what they can do as far as setbacks and lengths and depths, and, you know, the height is not limited by the size of the lot, but they comply to all of that. The only thing where they don't absolutely comply with today's regulations is the fact that they're asking for square footage to be counted for FAR, which is that which would be perfectly fine on a 2,500 square foot lot. Now, nobody here can increase the lot size administratively, right? Nobody can give them 200 square feet. So what the applicants are doing is, look, we have a small lot. It's smaller than even a standard lot. That's a special circumstance. It's a very small lot. It's one of the 4 smallest lots, I believe, in the immediate vicinity within the same zoning district, if memory serves, from remembering the staff report from the first meeting. That's special, right? It's a judgment call whether it's special or not. It's not for me to tell you that it's special. It's for you to interpret if you see that as special. To me, it is a special circumstance that applies to the lot. It's related to size, and they're not asking for, expanding a wall one side or another, making the lot area coverage bigger. They're not asking for more height. They're merely asking, look, in the calculus of FAR, we already got a 200 square foot deduction. Thank you very much. We'd like to extend the design by 139 square feet. Others in the district, in the same zoning district, in the immediate vicinity, already enjoy that privilege of having an FAR which is higher than the 0.72 that's allowed today. That was adopted for those 2 properties, I believe, before 2000. I see nowhere in the Brisbane Municipal Code that you are bound to ignore those 2 lots, those 2 properties, because they were built at a time where the current regulation had not been introduced. Does that hopefully answer part of your question?
Yes, thank you.
Any more questions for the applicant representative? No? Anything further, Mr. Bouchard?
As the deputized applicant representative, no, ma'am.
Okay, thank you.
Thank you.
Okay, Mr. Carter?
Chairperson and commissioners, as always, thank you for your service to the community of Brisbane. I know this is a lot of work to do, and I appreciate anybody that does serve our town. When I look at something like this, and I listen to the questions of Commissioner Patel, that was some good questions. And he talked about, am I supposed to ignore something that the city council members voted on? I believe that as a commissioner, you're here for a purpose, and that includes making decisions. And there is a basis that they have on the lot sizes and how much you can build on them. But there is a variance procedure. And if there was no variance, then it would be, doesn't matter what you say, we never need a variance. So we wouldn't even have that there. So I believe there has to be some interpretation, and you guys signed up for a purpose. And sometimes that's going to be interpreting and making a decision based on not the letter of the law, but on the interpretation of that and what they set up. If this was the standard size lot, this house would be within that, and it's not. And when they made the law, they consider everything they can think of, but they can't think of everything. And I'm not saying they did or didn't. But our community is a small community, and I'm here because when people buy a home here or property here, I want people to be able to enjoy their property and get the best out of that property they could. I mean, they're my neighbors. We support our community, and Brisbane's unique in that, right? We live in the middle of all this Bay Area, and it's just a unique town. So I think we think uniquely too, and we say, okay, this is what it says right here, but is this any different? And can there be an exception made to it? And there's only so many lots that would meet this circumstance. So it's not like you're saying every lot that conforms, we could give this to. But this lot doesn't meet the conforming to the regular size lot. So also the thing I add to it is right now, with the prices and everything that's going on in the Bay Area, families are, staying in their homes longer, including their children, and sometimes their parents have to come in. So when we're considering that, we're thinking about how much room do they need and how many people are going to live there. I know we don't want to overburden our streets and our parking, but this has plenty of parking in it. They've thought of that, and they've gone out of their way to think of it. So I love your commitment to what you're doing and listening to what the city council says, but you do also have a job to do, and that job has decisions to make that sometimes will vary from the letter of the law, and you have to interpret it. And then you have to come up with what you believe is a fair and equitable decision off of that. That's just my thought on it. I love the city of Brisbane, and I appreciate you guys serving, and I just hope you'd consider approving the variance.
Thank you. Anyone else who would like to speak? Okay, no one. May I have a motion to close the public hearing?
I move to close public hearing.
Second.
All in favor? Aye.
Aye.
Okay, let's start our discussion. Anyone would like to start?
Okay, so I've been going through basically since I asked to have this continued last time, any which way that I could think of to figure out how we could approve this particular plan. I think it's a sensible plan. I think it makes sense, but I don't know why the city council passed this resolution in 2003. I don't know what was going on at that time where they decreased the amount of square footage from 400 to 200. I don't know why they decided to have this particular percentage of volume allowed on the lot when everything else is conforming, but they did. I think that if they had just left it at 72% for standard lots, then we could have found a variance and saying this is a substandard lot, so we should find a variance and this plan makes sense. They didn't. They went farther and they said we are also going to consider substandard lots and give this particular additional square footage, and it's not going to be 400, it's going to be 200. So they discussed all of these things as it relates to the volume of building that they were going to allow on pieces of property for whatever reason, which I can't really figure out, or why they would do that when everything else is conforming. And I haven't been able to figure out how we get to approve this plan. So I think that the city council should re-examine why they made this law and maybe get rid of it. But as it relates to this particular project, I think that I have to adopt the resolution B119.
Anyone else like to comment?
Yes.
Commissioner Gooding.
Thank you. And at the previous meeting, I was one of the other vocal folks that was kind of agonizing about the issue. And my concern, or my qualms about complying with the staff's recommendation, was that there was a certain amount of worthiness of the project, of providing more parking. It's good for the community, it's good for the school, et cetera, et cetera. And that was my main thrust. And I spent the intervening time between meetings in part reading about the Office of Planning and Research of the Governor's Office provides some good guidance for local agencies and local entities about dealing with variances, and also some good case law. And there's actually a case on point that says that the community benefit or the worthiness of a project are not considerations in determining whether to approve a variance. It's a case called Orinda Association versus Board of Supervisors, which is really it pretty much punctures my entire argument that made me lean initially in favor of this particular variance. When you look at the numbers in this case, the amount by which the applicants would have to change their plan to conform with the required FIR are relatively small, which means it's fairly feasible. But given what I looked at in terms of the legal decisions and the criteria that are recommended, I concur with Commissioner Patel that I just can't find a way to shoehorn this into the requirements of a variance, and the findings the staff suggested we would have to reach in order to approve the variance. I just can't get to it. It doesn't appear to qualify. I may share Commissioner Patel's sentiment about the possibility of reexamining these, these strictures at the city council level, but that's not our job.
Thank you. Commissioner Mackin, do you have any comments?
Yes, thank you. There's been a lot of very impassioned people talking to us about our responsibilities, and one of our responsibilities I mentioned the last time, which is fairness. And despite many laudable sentiments by everybody in this community about the property owners and the family and their contributions to the community, we have to, as a planning commission, be guided by, are we granting special privileges? Because and I had to ask myself, if this was a nameless, faceless developer from out of state, would anybody even be here in this room? I don't think so. There's something else that Commissioner Gooding read from this governor's case law, and it says there's no basis for granting a variance if the circumstances of the project site cannot be distinguished from those on surrounding lots. And you could say, well, it's substandard, it's very small. There's a lot of those in Brisbane. I live on one of those, very small. So that a substandard lot doesn't have the same privilege as a standard lot. So a substandard lot doesn't have the same privilege as a substandard lot. But we could go on forever with that. And I think it's helpful to review a couple other things here as well. And I know, Mr. Bouchard, last time it's noted in our minutes that you mentioned where variance findings address special circumstances when a property can't conform to the code. This property can conform to the code. The proposal was for 138.5 square feet beyond the maximum FAR. And staff had noted for our benefit in examining this that a reduction of 73 square feet to achieve a 400 square foot 2-car garage would result in a 65 square foot remaining excess FAR. That's small. So to meet the FAR is easily met by a design modification. We heard last time lots of talk about they're going to have a 2-car garage, it's going to help parking. They could still have a 2-car garage, 2 extra spaces out front where this previously had been a 1-car garage. The extra workspace in the garage, while I understand, I like all that too, it's not a special circumstance. It's a design choice. It's a property owner's choice. And I understand trying to maximize the most out of what you have, but when you buy a substandard lot and you know going in that there's an FAR, that's what it is. I just think that it's very clear here. And if in fact, because we're told about housing crisis and maximizing what you build on a property, don't think it's the jurisdiction of the planning code to start making blanket decisions against the code that the council put in place. Then I would suggest that you lobby the city council to re-examine both parking and substandard lots. But when that last ordinance was put in place, it specifically addressed those substandard lots, and there was a reason behind it. And I don't see any special circumstances on this case that justify granting the variance based on what we've been given. So that's my opinion.
Thank you, Commissioner Mackin. Well, and thank you to all my fellow commissioners for your comments. I think, we've all took the time during the prior meetings to really try to think of ways that we could approve this variance. I mean, we understand the community generally supports this project, and there's no visible harm. Why not give them the home that they want? But like what Commissioner Mackin and all my fellow commissioners here have stated, we have to act within the code, and we have to treat everyone fairly. And if we give an exception to this applicant, what happens when another applicant comes and says, well, we just want a little tweak, we just want to a little more square footage, it's not gonna hurt anybody. Then it starts opening a whole Pandora's box. And then, if it's not your friendly neighbor, if it is the big developer that comes in and says, well, you granted it to this person, why not us, just because we're a developer? Are you giving them privileges that you're not giving us? So those are things that we have to consider, not only acting within the law, but thinking, any decision we make, what kind of doors or floodgates are we gonna open ourselves to? And, I just think that, codes and laws are written for a purpose, and I think, I don't see any special circumstances here that exist that would, warrant the granting of this variance. So those are my comments. Anybody else? Okay, so can I have a motion? Or should I?
I'll make a motion. I would make a motion that we deny the variance V-1-19 and approve the grading review EX-1-19.
Do I have a second?
Second.
All in favor?
Aye.
Okay,
Through the chair, you might want to announce the appeal
yes, I
procedure.
will. So now read the appeals process. Anyone may appeal the action of the Planning Commission to the City Council, except where specified otherwise. Appeals shall be filed with the city clerk not later than 15 calendar days following the commission's decision. Exceptions to the 15 days filing period include the following. Appeals shall be filed with the city clerk within 6 calendar days of the commission's action for use permits and variances, and 10 calendar days for tentative maps and advertising sign applications. An application and form and fee is required to make the formal appeal. Okay, next item on the agenda is, I guess we can discuss an item that was on the consent calendar that was removed, the general plan conformity.
It's up to the pleasure of the commission. I give you the brief summary, or if you just want to jump into questions, whatever you wish.
I just have a question.
Okay, go ahead.
How was it valuated? How was the value achieved that it was $200,000?
That was a negotiation between the city council and the property owner.
So there was no appraisal done or anything like that.
There's no formal appraisal, correct?
Is that routine?
Again, the city attorney is involved in all those negotiations with the council, and as you're well aware, the city cannot be in a position of gifting private property. So, is the consensus of the city attorney that essentially that the market value of that property, the paid price would have exceeded the appraised value. That's basically, it's not a formal process, but they do look at other economic conditions, other situations they're aware of, and that was based on. There's no requirement under law for a formal appraisal in every instance.
Are the negotiations, when the negotiations happen, is it in public or is it a private negotiation?
Real estate negotiations under state law are typically handled in closed session, and then the council reports out what the final decision was, which is what was done in this case.
Are there reasons why a certain price was achieved discussed when they say what the price is going to be?
I wasn't involved in what happened in closed session, and I wouldn't be in a position to discuss those negotiations.
No. When the city council announces that they're going to sell a piece of property located at a certain place and certain square feet for a certain amount of money, do they put the reasons why or how they achieved that price in a public record somehow?
Not that I'm aware of.
I had one question also, if you're,
No, go ahead.
mine is really just process. We're brought this now, at this point in time, long after the original development agreement was adopted. did the original development agreement anticipate or contemplate explicitly this action taking place now of the deeding of this sort of storefront?
Yes, it did.
Okay.
It becomes basically an implementation measure of an approved agreement.
This is not an add-on or an incremental grant or session. It was
That was part and
anticipated.
parcel to the original
Okay.
entitlement.
Thank you.
And that was from 2008.
Correct.
That's why it's on the consent calendar, huh?
Yeah.
Now I get it. Thank you.
Any other questions?
No.
Okay, so can I have a motion then that we approve the general plan conformity along with the consent, with the consent calendar?
So moved.
Just, you take a action on the case itself, the consent calendar's that ship is sailed.
Oh, okay,
So,
okay. So can I move, so is there a motion for us to,
just adopt the resolution would be the recommendation. Adopt
okay,
GPC Resolution 1-19.
so we have a motion?
Commissioner
yeah.
Gooding made the motion.
I'll move that
Okay,
one.
second,
I'll second.
all in favor?
Aye.
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 Okay, next we have items initiated by staff.
I don't know that we have any announcements, but a reminder to send me any conflicts that you have this summer. I'm sure you don't have any conflicts with commission meetings, but in case any come up, please let us know as soon as you can. We are going to cancel the July 11th meeting. So,
That raised a question I had. What does the July 4th holiday do to, I think maybe you answered it by inference or by implication. Instead of having a July,
so your next meeting would have been July 11th.
right,
So the 4th would be the week prior to that.
you're also canceling the 11th. So the next one is the 8th.
What? I'm sorry, we're only canceling the 11th.
Right.
Okay.
So then the one after that would be when?
Uh,
The 20.
2 weeks after that, the 20.
25th? Okay, good, thank you.
Sorry.
Okay.
And I believe that's it, or anything for June 6th council? No?
Okay, thank you. Items initiated by commission? Okay, we have none. Okay, can I have a motion that we adjourn to our next regular meeting of June 13, 2019?
So moved.
I'll second.
All in favor?
Aye.
Aye.